everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote mediation in the world around us and to talk about mediation from the perspective of a common voice. Today, we are indeed going to talk about mediation. So, let me just start sharing my screen because we are going to talk about mediation, and this is a bigger screen. It's So today we are going to talk about the role and procedure of mediation, what to expect in mediation proceedings, family mediation, child-focused mediation, parental alienation as distinguished from parental estrangement, how a mediator can help in parental alienation and domestic violence. Well, mediation is voluntary, party-centered, structured negotiation process conducted by neutral third party in which use of specialized communication techniques are used to assist parties in resolving their disputes. So what is mediation is voluntary and party centered. What does that mean? Well, parties are the focal point of a mediation proceeding. They have ownership of their dispute. They have the right to determine terms of settlement. The process does not follow the rules of evidence, and the final decision authority is party. So actually, if you see, everything is revolved around the party. The right of self-determination, autonomy is thus this just gives a legal sanctity to the agreement. Why this is a structured process? Because it has identifiable stages to facilitate resolution. It is not an extempore or casual process. Not just two people are sitting outside the court and with an independent mediator and they're trying to resolve it. It's not that because there is a degree of flexibility in stages, but these stages are very well pronounced and they are very much instrumental in the process. We will see that why it is a structured process and what do you expect in mediation? Well, it is a negotiation process conducted by neutral third party, so it is a legal process. It is warm and friendly. It has at the end of it a written and signed agreement. Voluntary process without any conflict of interest. The parties have come on the mediation table on their free voluntary will, and there has not been any compulsion of any kind. There is no conflict of interest, and the parties have not been involved in the same subject matter elsewhere. The matter at the hand is not before any court or tribunal at the moment when mediation is happening. So, why this is important? Because if even if it is a court annexed mediation, maybe it is a court ordered mediation, then also it is very essential that the mediation process is carried out by the parties will and the agreement will be actually passed, agreement will be or the settlement terms would be the parties' free will. Even if it is a court annexed mediation, even if it is a court ordered. So, and most importantly, when the mediation proceedings is going on, and if it is a court annexed mediation, the court proceedings will halt at that moment. Only one proceedings can happen, either mediation or the court, not both of them together. So that is one of the aspects of mediation. Let's look at what to expect in mediation proceedings. It is not an adjudicatory process. It's not an arbitration or a court trial. Mediator actively participates in exploring settlement options. Unlike a court uh, dispute where uh, the parties are not allowed to speak, mediation is totally a focused on parties' wish, on parties' desire to enter into an agreement. So it is, and most importantly, it is not a mere investigatory process where a mediator facilitates communication between the parties. It, the mediator is not looking for the right or wrong or for finding faults, whose fault is it, or who is legally right. That's not where uh, how mediation proceedings are. Mediator does not have a personal stake in the outcome. This is very important because uh, has a neutral and a detached perspective. Mediator takes every interest in the dispute, but at the end, whatever the outcome, mediator is not having any any interest in that outcome. That gives a neutrality and detached perspective of the. So this is what you will be expecting in a mediation proceeding. So how does it work? What is the scientific approach behind? Well, it is a combination, it is a process of specialized communication techniques in a controlled environment where careful and calculated interventions are done by the mediator to help resolve this. It is an assisted negotiation and not just problem solving. What is that? Because it involves a lot of skills of a mediator to ask questions when the mediator sees that the proceedings are working or moving in a direction where the parties are not able to come or they are moving more towards their positions. They're round and round going in their problems, but they are not trying to or blame game, but they are not trying to find a resolution. The mediator will carefully intervene, guide them with the use of specialized communication skills by asking relevant questions and help in creating mutually satisfying solutions. So, mediation is basically a facilitative approach. What does that mean? Well, it means that the mediation structures the process to assist the parties in reaching mutually agreeable solutions. It, a mediator will ask questions, validates and normalizes point of view, helps parties finding or understanding each other's point of view, assisting in finding amicable solutions that are best for both. But a mediator will not make recommendations or give advice, predict the recourse of the court. But however, let's talk about evaluative mediation, which is sharp contrast to facilitative mediation. Mediators are more likely to make recommendations, suggestions, and express their opinion. The focus is on not on the underlying interest, but more on the legal merits or the argument. Let's understand what it means. Well, more focus is on the legal merits. What is going to happen? Who is right and wrong? In evaluative mediation, generally the parties or the mediator is having a legal background or a technical expertise, and they are going to actively make fairness determination. More recommendations and suggestions are from the mediator to help parties or to assist in finding a resolution which is very important for the process for that particular dispute. It is more often used in court and ex mediation. So let's talk about first what is the basic difference in approaches. When we talk about facilitative interest based, they help this kind of a mediation help parties evaluate and develop interest based proposals. Whereas in evaluative, parties think of the position based proposal. What is the difference here? Well, in based proposals, the parties are looking at the long term interest, their underlying interest, and in evaluative form, the parties are looking at the what are their legal position? What is the position of the what is the position with respect to this particular dispute? Let me take an example to make it more easier. In facilitative mode of mediation, let's take commercial example only. Maybe the labor union and the management. Now, this relationship and the dispute affecting this relationship is going to have a long-term impact. And so the facilitative mode uh, of dispute resolution is most important here to understand the underlying causes of the dispute, to work at workable solutions to repair the relationship, because this relationship is going to be a long-term relationship between the parties. The focus of the discussion would be on the underlying interest, the long-term interest. Whereas, let's take an example of evaluative or position-based, uh, maybe a commercial dispute between a on a construction site between the construction manager and maybe the engineers, or the contractor and the engineer, regarding the quality of the raw material being used. Now, here in this kind of a mediation, there is no long term interest. The construction is stopped because of this dispute, and it is very imperative to understand what the dispute is and to resolve it as soon as possible. So, the interest basically is to resolve the dispute, to think of the possible solution to resolve this dispute, and to think of the legal claims and you know court outcomes also, because that will help in assessing the strengths and weaknesses of this dispute and to help it resolve quickly. So now evaluative or position based and facilitative or interest based mediation, uh, you can understand the difference why uh, both the mediations and both are necessary for dispute resolution. There is another sorry, there is another approaches. There are other approaches which is narrative mediation and transformative mediation, which are relatively new styles of mediation, where the focus is on creating a new story or a new narrative to, to the fact, where the mediator would try and the skills of a mediator play a very important role here, because the mediator will try to find a new narrative to understand and reshape the narrative of the conflict from the perspective of the other person, to make understand the positions of both the people. The narrative could be changed by the mediator to make both the parties understand why the conflict started, how the conflict started, what is a different viewpoint to see the conflict. In a transformative mediation, it is encouraging the disputants to recognize and accept each other's strengths and weaknesses. Because in certain disputes where it doesn't aim to transform the dispute, but such kind of mediation aims at transforming the relationship of the party, to make constructive change in their attitude towards each other. These this kind of a mediation handles the relationship aspect of the dispute. So we'll not go from a common person's perspective. This is just to tell you how different methods are there for mediation and how it has a scientific approach to it. What are the components of mediation? Well, the mediator is first of all impartial and neutral. He's empathetic and understanding, speaks the language of parties. The environment is informal at a private location, convenient and comfortable for all parties. The process is definitely confidential with explicit ground rules, clear and simple. The authority of communication is there with everyone, primarily a facilitator and not a judge. The mediator has the authority of communication. He is the master of the process, and he is not a judge. He's not going to judge the dispute or the people involved. There are some ground rules that the party needs to adhere to, and for the process to work smoothly. And the mediator sees to it that he is able to control this communication and to find some discipline in the process. Well, it is a problem solving. It deals with all aspects of the larger problem. It helps parties to look at the strengths and weaknesses of their respective cases. So that is a great advantage here, because generally in an adjudicatory process, the parties will not be able to have a problem solving attitude. It will be more of a who is right and who is wrong. The creative options of solutions is a very is I could say is a USP of the mediation process, because it aims to resolve the underlying sources of friction which might not happen in a court proceeding or maybe in any other form of dispute resolution. So there is a lot happening in the mediation room that could be understood by the common persons, for the common person. Mediation bridges the gap and opens the channels of communication. It restores the balance, strikes a bargain, and stops violence, attacks, and friction, even verbal attacks on each other. It meets the parties' real interest, allows the parties to cooperate on future tasks. So that's a small icon to make this one interesting. So what is an opening statement? What will you expect in an opening statement? There will be an opening statement where the mediator will tell you about the introduce you, then he or she will tell you about the role, the procedure, the ground rules, and the agreement and authority to sign. He will check. So basically, there will be an introduction of the parties. Mediator will encourage the parties to introduce themselves, obtain names, identity, and ask how best to address them. Then identify whether they are the same parties who will be signing the agreement, or they have the authority to take decisions, generate options, offers throughout the process, because this is very important. There might be commercial disputes where a manager or HR manager of a company might be representing, but may not have he may not be the signing authority or an authority to take decision or generate options. In that case, the mediation would not happen and move further, because it is very important that the person who is in the mediation should have the authority to take decisions and generate options or offers. So what is the process actually? First of all, happens the information gathering of facts. Then there are clarification or formation of issues. What are the issues? Then brainstorming or ideas or construction of possible solutions that could happen to the issues, and then signing of the agreement with the resolution. So that's basically introduction, gathering information, problem identification, generation, selection of options, and settlement. So it's a very scientific, and this is how it is a structured process. as like I was telling. Now there is a private session, which is the caucus session. Why is it required? It is required and needed to discuss various options that the parties may be hesitating to agree due to ego or acrimony between them. It is essential to make an assessment of strengths and weaknesses to help them take a rational decision to counter or help in power imbalance. There could be a point where one of the parties is more empowered and the other one is weak in their dispute, and maybe they are not able to speak. So it is important that uh, the mediator would take a private session with both the parties to emphasize the advantages of an amicable solution to the stronger party and to empower the weaker party by, selecting very, discussing or suggesting or even, brainstorming various options. Now, when the parties have come to the mediation after several attempts of failure, then they might not be willing to, be in one room with the same party. So, caucus session helps to resolve and sifting through the baggage of the failed attempts to resolve disputes. That's also one of the reasons where caucus session would be needed. And then one more important issue is that determining domestic violence and parent alienation cases and help thereof, because these are the cases where parties may not be willing to come out in open in front of the other party, or they may not be able to do that. So in a caucus session or in a private session, the mediator with the confidentiality there, uh, the parties can more truthfully come out with whatever they are having the issues. What is a mediator's pause? During a mediation session, sometimes uncomfortable or difficult position or, that could result in a pause or break from the session. So that, and there could be a number of reasons for the pause. Why the pause is necessary is that sometimes it brings a break to the monotony that is going on. Maybe a short 5 minutes break, like I'm taking a break right now for having a sip of water. That that makes a lot of difference. And actually taking a pause could be beneficial for both parties as well as a mediator. Now, most important is what is the special emphasis in family mediation? Division of resources and finances are obviously there, then custody of children. But a good mediator would also focus on upbringing and responsibility sharing. Children need time and attention of both the parents. Need to evaluate the best interest for the future progeny. Financial decisions to be taken, keeping in consideration the future of children, division of finances, and to keeping in consideration the well-being of the entire family, everybody. Because the husband and wife are getting divorced, but children, or there could be endeavors or there could be solutions where the family could be kept intact. Some aspects of the family could be kept intact for the functional benefit of children. And those solutions can also come from discussion. So that is how mediation is really effective than uh, adjudicatory process. So when we are discussing when child-focused mediation happens, so a parent's physical, financial ability and willingness to co-parent is most important. Then time sharing has to be decided among parents. because parent separation will leave a big emotional impact on children. How parents are going to deal with it, how children are going to deal with it. It is very important to discuss all these issues. Then there could be a need for interaction with children, especially adolescents. And so a mediator could suggest measures like a counselor, if that is required, need of specially abled children, because the specially abled children could have a little different needs from, financially, maybe emotionally, maybe physically, they might need a little more help. So these kind of issues have to be discussed in child-focused mediation. Then handling parental alienation cases that we'll see in later slides. There could be points of agreement or disagreement. Who will be the custodial parent? How much contact will be the non-custodial parent have with the child? How will the child have contact with other family members, relatives, uncles, aunts, grandparents? Because interaction with all these relations are very important for the emotional growth of the child. And the child has been living in such an environment with such grandparents that taking away the child from this support is not advisable. So in a child focused mediation, these issues need to be discussed. Who will take the decisions about the child with respect to the higher education? How much communication between the parents and their mode of communication? Because this is very important that the child sees their parent as teammates, as not as enemy. That is really important. That is, and if mediation is successful and all these issues are handled, then really it really makes a difference to the children. When we talk about children's rights here, Article 9 of the UN Convention on the Rights of the Child states that a child shall not be separated from his or her parent against their will except when the competent authority, subject to judicial review, determine in accordance with the applicable law and procedure, such separation is necessary for the best interest of the child. Such determination may be necessary when there are cases of huge neglect by the children of the children by the parents, or one of the parents are living separately. Then decision has to be taken. But apart from that, a child should not be separated from their parents. That's what. And in subpara 2, it says that any proceedings pursuant to paragraph 1 of the present article, all interested parties shall be given an opportunity to participate and make their views known. The parties shall respect the right of the child who is separated from one or both parents to maintain personal relations and direct contact with both parents on regular basis, except if it is contrary to the child's benefit. So we understand now why mediation, or how mediation can be really helpful. Let's understand parental alienation and the genesis of it. Well, this term was first coined in 1985 by Richard Gardner, a US-based practitioner working in the field of psychiatry and psychology. Now, he gave two definitions of alienation and parental alienation syndrome. There are many definitions of parental alienation where, Gardner says that a damaged or severed relationship between a child and a targeted parent caused by the alienated parent. And he describes syndrome as a disorder that arises primarily in context of child custody disputes. It is the manifestation of child's campaign or denigration against the parent, a campaign that has no justification. The disorder results from combination of indoctrination by the alienating parent or the child's own contribution to vilification of the alien. So, in simple words, if we say a strategy where one parent intentionally displays to the child unjustified negativity aimed at the other. The purpose is to damage the child's relationship with the other parent, to you know, uh, turn child's emotions against that parent. It could be combination of indoctrination by the alienating parent and also child's own feelings, emotions, and perceptions in vilification. Why this could be happening? As Gardner says, it's a parental, syndrome, parental alienation. Well, when the child is growing up in circumstances where he has seen disputes, fights, then obviously in the mind of the child, one of the parent will become a villain, and he will have more sympathy towards other parent. So he starts alienating that parent who is a villain in his perceived perception. So, or it could be, indoctrination by one of the parents. So when we talk about parental estrangement, this term is also important to understand where mediation can help us. Well, there is not a single definition, but estrangement is being defined as a situation where there is a conflict between the parents and the family law system contributes to the breakdown of relationship. Or such an estrangement has occurred for a good reason. What are those good reasons? We have already seen, or the family law system feels that the parent, one of the parent, is not it's not good or in the best interest of the child to be with them. So that is defined as parental estrangement. Let's talk where what if why parental alienation is a global issue on the rise, because this abuse is targeted both against the child and the parent, and it may be a covert abuse which is generally hidden and goes unacknowledged. Now, covert abusers may isolate or gaslight their target. They may threaten violence against them, or it may be in a form of verbal or emotional abuse or any other domestic violence abuse. In most cases, the perpetrator refuses to acknowledge the abuse and instead suggests the victim is responsible for the abuse. Or the abuse is the result of action or omission on part of the victim. So when they are confronted, the perpetrator will either totally deny such an abuse or they will blame it on the other person. So there have been cases in the study, it has been mentioned that where perpetrators of domestic violence use parental alienation as a tactic to discredit reports. So what is the impact on the children? Let's try and understand that, because then we have seen what is parental alienation, where how it is affecting globally. Let's understand the psychological impact on children. This could be, a long bearing, and it may remain well till they grow up as well. Because alienating parent may think that such an alienation may win the child on their side, without realizing that child is totally having an emotional impact, and the child may altogether lose faith in intimate human relationship or even marriage. And quite often, the alienating parent can go to the extent of suspending emotional, physical, or financial support to the child to get them to submit to their wish. And such a behavior can ultimately lead to anxious, anxious adults later on in life, and they can instill hostility in the children. So, how can mediation help? The long term impacts of such situations on children as individuals and as a society as a whole cannot be undermined. But there is a fact that there is a lack of judicial guidelines or policies to protect them and monitor the impact on children. And it is also not possible, I would say, because the gravity of the emotional impact on any individual in a particular situation, that's what I feel, it cannot be measured. So there could be false allegations also of parental alienation, and these could be equally destructive, just as false allegations of domestic violence. Hence, there is a much need of transparency in such matters. Now, where we talk about transparency, the voluntary and confidential attribute of mediation are the first thing that can help, and they can ensure transparency and honesty in relationship. So that's where mediation comes and it plays a big role here. Because there might be situations where the parties may not even be aware or realize that their actions have been violated. That is, we are talking about the perpetrator, who might not realize also, and they might consider such actions as a normal part of human relationship. So they might not be able to disclose such issues also. But a trained mediator can listen to both the parties, their verbal and non-verbal communication. A lot is happening inside the mediation room. You know, there are looks being glanced. There is anger in demeanor, in body language being exchanged, and these a trained mediator is 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 trained to look through, to see through all that. They can ask relevant questions to determine if there are any acts of domestic violence or parental alienation happening. Now, whereas uh, we commonly, for a common person, it is normally understood that domestic violence are just acts of aggression, brutality, resulting in mental or physical torture. But let me tell you that inappropriate communication between the parties, ignoring the importance and worth of a partner, uh, giving silent treatment, condemning tone, undermining the importance of the partner, or communicating sarcastically in front in conversation, or making indecent jokes about them, or you know all these are instances of unhealthy relationships, and quite often such signs are not are they are generally overlooked. They are not significant. They don't become significant enough to be pointed out. So there could also be a pattern of alienating, alienation inflicted by other families. Generally, in joint families, the the paternal grandparent or uncles and aunts living together or maybe interacting with the children could be talking about their mother, one of the parents, or their father, if it is the maternal grandparents or their family, or anybody who is associated could be talking ill about one of the parent, and this would bring bad thoughts or alienating thoughts in the child's mind. This could be affecting the child emotionally. So these kind of patterns, which are inflicted by other family members or in joint families, which are directed towards one of the parents, they often go unnoticed because they they are not considered insignificant enough to be discussed, but they are a grave cause of concern in relationship. And such behaviors are discussed by the mediator. The mediator helps parties analyze the real reasons behind their conflict and make them aware of such behaviors so that they might consider working on them. And when they are able to address such issues, that's where mediation really starts helping. So, what is the mediator's role here? Well, we have already seen that parental alienation cases, the transparency and the need to discuss the issues by both the parents together with an independent person who pays attention to the details, spoken or otherwise, the body language, the non-verbal communication, ask appropriate questions, dealing with or determining domestic violence or parental alienation. Sometimes he or she might take focus sessions separately to address such issues. This helps him to foster positive communication, helps the parties to see each other's point of view. This is really important because that's how a mediator will, that's how, but that's the exact role of a mediator. That's how a mediator will help the party to see where they are going wrong, the real cause of whatever the apparent dispute they have. And that is how and where a mediator is able to help, where the legal system, where the judicial system, or where the adjudicatory system is not able to help. That's where mediation really helps people. That's why it is very important to understand the concept from the perspective of a common person and to understand why, what are the benefits. First of all, let's summarize and say, see, if it is mediation, which is a flexible and informal way of dealing with conflict. Such a process is very time consuming, definitely. And so it will not be explored in the court proceeding. It is not possible to explore in the court proceedings because the gravity of the situation could be very case sensitive. It is not possible to understand, and the court will always be looking at the legal aspects of it. Although the family courts are very, very concerned, they have a child focused approach. They try to help people, but then they have their own limitations because this process will is 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 really time consuming. It involves a lot of skills of the mediator, the communication skills, the process which aims at starting, like we saw, that the structured process. So mediator can really help raise the concerns with one spouse, and mediator can really help the parties because the mediation is being a private and confidential process. It ensures that no public record is maintained of the proceeding, and if mediation fails, there is always an option to take recourse of the court. But when it's a confidential and private process, generally the parties come out. There is transparency, there is honesty, because when we understand that we have to resolve this issue, and there is nobody judging us, we can come out in open, we can discuss our issues with the spouse, we can think of possible solutions, because everybody in the end would really need peace of mind. And mediation is a process that is the USP of it, that everybody is a winner. Both the parties are in a win-win situation. Nobody is losing. Nobody is winning, and nobody is being defeated. Not one person is winning and the other person is being defeated. It is a win-win situation for both the parties. So in the end, I would I could say that a mediator in the family proceedings is just a pillion rider in in a dual steering vehicle where both the parties are going in separate direction. But this billion rider has to be a best navigator in order to make things move and make things move in a good direction, in a win-win situation for both of them. That that was a short PPT which was aimed at at bringing the importance and to make people understand what is mediation and why it is necessary, why people around the world are talking about it. It has been a long PPT, and I appreciate if people are have patience to go through it. It has taken a lot of research work to understand the concept, to bring out the concept as the world is seeing them. And I can say only that we as a human race are an evolved race. And it's about time that we start behaving like an evolved race and we start making a difference to our relationship. We take the responsibility of our own emotions, our own behavior, and our own disputes. With the help of a professional who can help you, who is there to help you, who is trained to help you, and who is willing to help. Thank you so much. Namaste.